SJC-12370, AL Prime Energy Consultant Inc. v. MBTA.
Mr. Martin, good morning.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court, Kevin Martin for the MBTA. With me today I have Joshua Bone. Your Honors, the contract between MBTA and AL Prime explicitly gave MBTA the right to terminate it for any reason in MBTA's sole discretion with no liability for anticipatory profits. MBTA therefore had every right to terminate that contract to save taxpayer money by moving to the Operational Services Division's lower-cost statewide fuel procurement program. The Superior Court's decision, which brushed past the language of this specific contract to rule that state agencies always act in bad faith if they terminate a contract to move to a lower-cost supplier to save taxpayer money, was wrong as a matter of law, is dangerous as a matter of public policy, and we are asking this Court to reverse it.
I understand, sort of jumping ahead to the arguments of AL Prime. I understand they didn't plead anything dealing with the bidding process, but the clause you're talking about also has a termination for convenience provision in it, at least as it relates to the remedy. But it seems that their position is that the implications here, as a matter of public policy and the integrity of the bidding process, are quite serious systemically, because who's going to put this type of bid out long-term if it can be undercut without the language that are in the federal cases, the Totello case and the federal court? Kurgowski case?
Kurgowski, Your Honor?
Yeah, so what's your response to that? I know your first response is, well, they didn't plead it.
Right.
But beyond that.
So there were a few reasons, Your Honor, why the bidding argument they've made really does not pose a concern as a matter of public policy. The first is that this was, in fact, in the RFP. And so anyone looking at the RFP could have seen that this particular termination for convenience, for any reason clause was there. And they could have taken that into account in deciding whether to bid and how much to bid. For all we know, there were people who did not bid or who bid more than AL Prime did because they looked at this and said, we want extra protection. Right now, AL Prime is trying to get the benefit of something that it didn't bid for, which is a contract which does not allow termination for any reason, which does not have a preclusion of an anticipatory profits award. The second reason why this shouldn't really be a concern is that if it is, the legislature always can deal with it. And there are many statutes in the Commonwealth which deal with bidding for state agency contracts. None of them apply to this particular procurement. MBTA is carved out of many of these statutes as a matter of law. And the ones which do exist, including the ones which do apply to MBTA, don't apply here. And they certainly do not say that even if you have a termination for convenience clause that's as broad as this one and that precludes an award of anticipatory profits, that language in the contract must be ignored, that it's void as a matter of law. This is also, it's a somewhat self-policing issue. If bidders don't like this language in contracts, they simply won't bid or they'll bid more, and agencies will learn their lesson and they won't include it anymore. But these kinds of termination for convenience clauses, whether they're the more vague termination for convenience clauses, which just say for convenience, or whether they're the very specific termination for convenience clause that MBTA put into this RFP and that AL Prime accepted, they're out there and they should be interpreted according to their plain language, as every other state's court that we cite in our brief has done.
I guess the response to that would be that the clause does mention the federal acquisition regulations and that somebody bidding might contemplate the determination language is the same as some of these federal cases that started with the Torcello case.
It mentions the federal acquisition regulation, but in a very specific context. It's only with respect to the calculation of the payment you get if there's a termination for convenience. The FAR is not mentioned in the discussion in the contract of the circumstances under which a termination for convenience can occur. The language there is very clear, and it's very different than what you find in the FAR. The FAR simply says, in the government's interest. That language doesn't appear in this contract. This contract has a different set of circumstances, which is in the MBTA's sole discretion and for any reason. And I'll note, too, this was a potentially up to a $130 million contract. Somebody looking at this contract would not quickly glance through it and see a reference to FAR and mistake it for something it's not. Presumably, they studied this RFP very carefully and understood that the FAR was only being referenced for purposes of the calculation of the termination payment.
Can I ask, say we agree with you, I just want to make sure I understand how they got profit on work performed. How do we know, say we accept your interpretation of this, but I read your brief as being very stingy about what they're entitled to. What is, I mean, you're saying they got their payments, but
So what they're entitled to, Justice Kafker?
because there are two types of profit discussed in the bid, right? Anticipatory profit, you're not allowed, but you're also allowed to collect profit on work performed.
Correct.
So how is that dealt with by?
So they would be paid for fuel through the delivery date, and the way this contract was set up, they were paid the cost of the fuel under the according to Platts, which is a delivery point in New York.
Right.
Plus a certain number of cents per gallon on top of that.
So that is an objective number that can be calculated. If you're right, there's a clear answer to how much they're entitled to for that type of profit.
Correct, and they were paid. I mean, they performed, because they performed under the contract for about half the life of the contract. During that nearly 12-month period, they would have been paid, and they were paid for their fuel, which was actually delivered.
I understand they're paid for their fuel, but you're saying there's a surcharge on top of that constitutes profit?
Correct. So they would submit an invoice, which would be, we delivered X gallons, and here's how much we get per gallon. The amount they get per gallon consists of the Platts price plus their profit margin, which the RFP allowed them to, or required them to include in their bid. And that's how they were selected. They proposed the lowest profit margin of the various bidders.
So that's, I take it your answer is then that if they're allowed to collect their bid preparation costs, they're allowed to collect their, how much, they charged, and they're allowed this profit, even if this is tough business, they've still been fairly compensated, I take it.
They have been, Your Honor. They've received, as you note, their profit on the work they actually performed, and they get their ramp up and ramp down costs. And this is where the FAR comes in. That delineates what they're allowed to obtain upon the termination. And I would note one thing which distinguishes this case from some of the federal cases where concerns around the bidding process have been raised is that here they were entitled to, at a minimum, a 30-day period in which they would be meeting our fuel requirements and receiving their profit and eventually their ramp up and ramp down costs. In cases like Torcello, or Colonial Metals, which is another case discussed in Kurgosky, there was no guarantee of any performance. And in fact, there was no performance. So in the Torcello case, there was a contract for 12 different types of services at a Navy base. And there was a termination for convenience clause, but there was no sort of guarantee that anything would ever actually be ordered under that contract, and nothing ever was ordered under that contract. And that's very different from a case like this one, where we know that they were at least going to get a 30-day period in which they were delivering fuel to us. So there was a certain amount of consideration which was guaranteed. And simply as a matter of public policy and of law, there's nothing wrong with it. What's in effect a put option, right? We had.
Go ahead. I'm sorry. Please.
Sorry, we had the option to get out of this contract as long as we then paid them for another 30 days worth of services under the contract. So unlike a case like Torcello or Colonial Metals, there was consideration guaranteed here, and that distinguishes this from the policies that were animating the Federal Circuit and the Court of Federal Claims in those earlier federal cases.
So what about, let's talk about the state case for a moment, because the Morton Street LLC versus Sheriff of Suffolk County.
Right.
You have diametrically different views of what that case means. And as I understand Ale Prime's position is basically, well, they really needed the money in that situation. There were serious budgetary issues. And here, if there were serious budgetary issues, it's not in the complaint, and that's the difference.
Right. And we have the author of Morton Street on the bench, so I'll be careful what I say here. But as we read Morton Street,
If only he were alive today.
oh, sorry, maybe I'm mistaken. As we read Morton Street, the court only decided in Morton Street that the facts there were sufficient to allow a termination for convenience. The court certainly did not say that those facts were necessary. In Morton Street, the court was very clear that when you have a government agency which has to decide how to allocate scarce government resources, one reason why you might find it convenient to terminate a contract is to avoid having to make cuts somewhere else. And this court can take judicial notice, because it's all public record, that in 2015 and 2016, MBTA was operating under a budget deficit. And if it did not save money on this contract, then the new financial control board was going to need to find someplace else to save money in order to bring down its operating deficit. And so it made a decision to switch certain procurements from an MBTA procurement process to the Operational Services Division's procurement process, both so that MBTA would not have to undertake the effort of doing it itself, but also because the Operational Services Division entering statewide contracts can get better deals. And so it did that. In that way, it's very much like Morton Street. And I would note, too, in Morton Street...
But if you entered into the... I mean, those federal cases, the federal cases say that if you entered into it knowing you're going to blow it up, you're in trouble, right? Are you... Is that ruled out here? I mean, I'm a little troubled by they got a 30-day contract. They weren't bargaining for a 30-day contract. So if you entered into this thing with the idea that you're just going to do this for 30 days, that would be okay?
Well, Your Honor, ironically, one effect of saying that we can't terminate for convenience would be to shorten the period by which these sorts of contracts get bid out, right? You would encourage agencies to enter shorter-term contracts.
Yeah, but I mean, they entered into this. I mean, they entered into this thinking they weren't getting a 30-day contract. This is a huge undertaking, right? How much was the bid for this?
Well, the bid was for, if both option years were exercised, it was around $130 million contract,
Yeah, and it's
of which half was sort of the 2-year opening period. But again, this is a sophisticated company. They could look at the termination for convenience clause and see that we're allowed to terminate for any reason we want. And if we do, then they only have a 30-day further period in which they can deliver fuel. That is not a clause which appears in any of these federal contracts. And we would expect a large business capable of fulfilling this contract to read the language here, realize it's different from the language which appears in the federal contracts, and to understand what their rights and obligations are.
If I can carry a little bit further. Clearly, any reason cannot mean any reason. Certainly, if the reason to terminate it was because it was a black-owned business, that would not be permissible.
It would need to be any reason otherwise allowable by law. And so, for example, we couldn't do it in a discriminatory fashion. If this were actually an Anthony's Pier 4 type case where we tried to terminate in order to squeeze something from them, maybe there'd be an issue there. But in the ordinary course, and we've cited numerous cases from around the country in which state courts have looked at termination for convenience clauses. In the ordinary course, terminating a contract in order to save taxpayer money is an allowable purpose.
So what you're really asking us to say is that in the absence of any evidence that it is discriminatory or that it is a violation, that it's of the implicit covenant of good faith and fair dealing, and any evidence that it's contrary to public policy, you can do this.
Correct, Your Honor. That would be right.
And I guess your view is that getting a cost reduction is not contrary to public policy.
It's not, saving taxpayer money is not contrary to public policy. And in a situation where, again, the other side, the contracting party, unlike in those federal cases, is guaranteed some payment. Here, unlike in the federal cases, they get payment for at least the 30 days. There's consideration for the option that we bought ourselves. And so it's entirely consistent with the implied covenant of good faith and fair dealing too. They had to realize going into this contract that they were giving us the right to terminate it on 30 days' notice, and that they would not be allowed to seek the very damages they're seeking here, which is an award of anticipatory profits. That was explicitly written out of the contract.
Just one more step on the chief's questions. What about if I know that we don't have anything pled in this way, but what if the reason to terminate was something, well, gee, we'll sign this contract, but at the outset, we know that we're going to replace it in a year or 9 months. Would the federal cases kick in at that point?
They would not, and I would direct Your Honor to the Caldwell case, in which the Federal Circuit, and we cite this in our brief, the federal rule is even if you're aware of the facts that may someday lead you to exercise your termination for convenience clause at the outset of the contract, as long as you intend to perform under the contract for some period of time, then the Torncello rule is not implicated. If there are no further questions.
One last one. So okay, I'm all set, thanks.
Okay, thank you, Your Honors.
Okay, thank you. Mr. Murphy?
Good afternoon, Mr. Chief Justice. May it please the court. The language that the MBTA is relying on is 3 or 4 words in section 5.9.3 of an 84-page bid document. And the title of that section is Termination for Convenience. In the first sentence, the language talks about being able to terminate for its convenience and/or for any reason. That's where it appears. And then later, when it talks about limiting the remedy, it only refers to termination for convenience.
But, Mr. Murphy, you know that there's a heading not binding clause in the contract, first of all. And secondly, not just any words, the later language has to do with remedy. It says for any reason. I mean, they're not just any words.
No, they're not, but you cannot read those in isolation, Your Honor. You have to look at the entire contract and the purpose and background for this. This contract bound AL Prime for 4 years to supply all the requirements of the MBTA, a minimum of 14 million gallons of diesel fuel, every year for 4 years. The first two, it was a 2-year contract, and then the MBTA had 2 options. AL Prime had to be ready to provide that supply regardless of market changes, shortages in fuel, whatever occurred, and it had to stay at the same price, which was a differential. In other words, they took the benchmark price, Platts, and then they added the differential they would charge. So that was a 4-year contract, and for sealed bids. The MBTA went out and solicited this contract, and it asked bidders, I think there were 7, to submit sealed bids. And there's a reason for that. It's so that the bidders are treated in a fair and equitable manner. No one knows what somebody is bidding beforehand, and they can then go back and try to cut the price
But
or leverage one against the other.
All that, I mean, and I get that, and I suspect that the MBTA doesn't want to go through all this work if it's intending to blow this up in 30 days. So how are you harmed? Tell me how. Is it because you had to buy more equipment? Because you're getting paid, you're getting your bid prep costs, you're getting your profits as long as you're not getting your anticipatory profit. So tell me how you're hurt. I'd like to concretely understand that, because I do see why you're angry, and I'm just trying to understand your losses.
Yes, Your Honor, it's not a matter of being angry. It's just a matter of basic contract principles. It is, they could terminate on 30 days' notice, whereas Prime had to go out and secure this supply and be subject to liability if it couldn't secure this supply over a potential 4-year period at a stated price. Now, the MBTA, so I submit that 30 days of what should be a
Still aren't,
two-year,
you
maybe
haven't
four-
answered the question. I'm trying, I mean, how are you hurt here? Again, you get your bid prep costs, you get your profits, you don't get your anticipatory profits. Tell me how are you harmed? You're a big player here, you read the contracts. They didn't void the public bidding laws because they used another public bidding contract. So tell me how you're harmed.
The harm is the benefit of the bargain, Your Honor.
But you're
Because this-
getting your profits, you're just not getting your anticipatory profits,
Well,
right?
You say anticipatory profits, those are the profits that should have been realized if the contract was properly terminated. Now, the termination for convenience provision, you're right, Justice Lowy, that's the caption, although it is also referred to later. That has a real meaning, a real distinction, a real history to it. And there is no record in any long-term multi-year contract of any state agency in Massachusetts terminating a contract like this simply to get a better price. That undermines, that makes a mockery of the bidding process.
Well, usually when state agencies do this, they don't have another bid out there that they can draw on. They would have to rebid it. So this is an unusual circumstance, isn't it?
No, it isn't, Your Honor, because they knew what they were contracting for. They didn't, first of all, this is a motion to dismiss, so they have introduced a great deal of evidence by citation to MBTA publications. We've had no opportunity for discovery. But we do know, if you look at the OSD bid that they hooked onto later, that there was in fact a change in the terms of that contract just before they terminated Prime. So there was a renegotiation there. There was nothing in this contract which said, if we can get a better contract through another state agency, we can terminate. There was nothing like that. The Prime was not given the opportunity to rebid.
Well, their argument is going to be that it said for any reason at our convenience, at our discretion. How much more explicit could we be?
Well, there has to be some limitation to the discretion, and that's what all the cases say, Your Honor. The federal cases and then the state cases. The federal cases, the guidance is inconsistent from the Federal Court of Claims, but Kurgowski is really the controlling case because it acknowledged specifically that an example of bad faith would be terminating a contract solely in order to get a better price.
But
Then it went on to
aren't they
discuss-
citing cases where their intention is to blow it up right away? They're not, I mean, because the idea that, you don't want government to try to be efficient seems counterintuitive. I understand you don't want government to be cute, to put out a bid with the intention of blowing it up, or even putting out a bid, and if they don't like your guy, they're going to not do it. That's different.
But what Torncello went on to discuss at length, Your Honor, was, Kurgowski cited Torncello for that and said that the specific concern of the Torncello plurality about shopping a price out after a bid has been laid to rest by the recent enactment of the federal bidding and procurement statutes. And they cited that, and they said, so that's no longer a problem, and the emphasis is by following those statutes, you're going to ensure fair, full, and open bidding competition. What they want to do is...
Maybe that's a good idea, but that's sort of a legislative issue to deal with whether or not a provision like this is going to impact the integrity of the public bidding process. But MBTA's position is that this isn't even a termination for convenience clause. It isn't even that. And it seems to me what you're saying is a good point, which is that, well, if we knew realistically that 2 years into this or a year and a half into this, all of a sudden that there was a real risk for no reason that they could terminate the contract, then we would have had a higher bid. And that seems reasonable. But the response to that is, well, you read the clause, you were on notice. How do you respond to the MBTA on that issue?
Your Honor, again, looking at the 84-page bid and the multi-year contract here, the MBTA, and again, we have to look at this more broadly than simply them going to the OSD contract. So they're saying for any reason. So the reasonable expectation here was not that they could take full advantage of the contract when it was their interest, when the market maybe was not good, and then terminate it whenever they wanted, when the market wasn't in their interest or the contract wasn't solely in their favor, and go out and undercut it with someone else. That's what they want the right to do. So and the contract is illusory in that sense, because it's supposed to be a requirements contract, not just 14 million, but whatever we need, you have to provide. So the contract is illusory. Under their argument, that language would give them the right, the day after they sign the contract, to call up the second lowest bidder, third lowest bidder, and say, well, here's the price, can you beat it?
But they can't do that because they're bound by the public bidding laws, right? So they'd have to rebid that, and then the bid price would go dramatically up because of what they just did. So they wouldn't, that's not the real world, is it?
But Your Honor, they could do that after the contract is signed. They could do it a day after.
No, they couldn't.
Under their reading of the contract for any reason.
No, they'd have to, they can't violate the public bidding laws separately, right?
But it,
Because that would be a violation of the public bidding laws.
I'm saying that after they sign the contract.
Still would be a
There's
violation
still,
if they
you
tried.
still need to have a new bid.
Right.
Right, but in here, there was no new bid. We don't have a factual record developed, but Prime had asked if they would have the opportunity to rebid, and they were not even given that opportunity. You have here, you could have had them tell Prime, if you have this absolute unlimited discretion, they could tell Prime, we're going to cancel this contract unless you give us a better price.
I mean, how does this different from an employment at will contract? I mean, it's all the time. People enter into 2-year contracts, and the employer says you're at will. It's a 2-year contract, but I can fire you whenever I want to, as long as I don't discriminate or as long as I don't do it contrary to public policy.
A 2-year contract, Your Honor, would not be an employment at will. It would be employment for a specific period of time.
Could include a provision that says we're allowed to fire you for any particular reason.
Then the 2 years is meaningless.
Well, isn't that what every football contract is?
I don't know about football contracts, but I know about employment contracts. And the employment contracts and these type of contracts are supposed to have some sort of meaning. It's supposed to, the reasonable expectations of the parties should be honored here.
But
And that's
what reason did you have to expect anything other than what the termination provision gave you?
because the language is a termination for convenience. Page 8 of this
Yeah,
contract.
but I mean, we expect you to go back and go beyond the heading. And the fact that it's an 82-page contract or whatever the length is, if you're not looking at the termination provision, then you perhaps need new counsel.
The termination, but the termination for convenience is the only term used later. This contract, Your Honor, if I may, it was bid in accordance with the requirements of the Federal Transit Administration. And there's 10 or 20 pages of federal requirements which are imposed here, including the reference to the federal acquisition regulations. There has never been a situation that's been reported where an agency has gone out and got a long-term contract and then just said, we can now get a better deal, we're canceling it. What's the purpose of the bid? What's the good faith? It is taking away the reasonable expectations of the party. Now, I want to turn...
Can I ask you about Morton before you turn? So Morton's the sheriff, doesn't have the money to pay for the contract, right? The T is an incredible, I mean, I don't know if this record supports this, but I have to look at what the motion dismiss, but the T is under tremendous financial strain. Does that analogize to what's going on in Morton? I mean, the T is, literally dragging the state down. So, and again, I don't know if that's in the motion to dismiss at all. Is that not present? Do we not have the financial pressure on the T in the record that we're deciding?
Well, there's a reference to online documents, but not in the complaint. But taking for granted that there's pressure, financial pressure. And I was going to turn to Morton Street, Your Honor.
Okay, sorry.
It's a completely different case. Because in Morton Street, the sheriff of Suffolk County signed a 10-year lease after bids for a specific facility and made it clear to the landlord that this is based on separate funding we're getting. And if we don't continue to get that funding, we can't continue to lease the building. 3 years into the lease, the sheriff lost the funding and terminated for convenience. And this court said, that's a pretty easy call, because that's such a change in circumstances, loss of funding like this, that this court did not have to look at, determine the limits of the discretion of the government to terminate.
But if the T is under tremendous financial strain, I don't know, again, I have to look at the record, but there's a financial control board imposed upon the T. It's supposed to look under every seat cover for every nickel it can find. Does that fit within the Morton analysis?
No, Your Honor, and here's why. The sheriff lost the lease, terminated the lease, and didn't have that facility anymore. It wasn't just a matter of cost savings. They had to cut back. They lost the funding. Now, if you look at the termination for convenience provisions, they talk about, it gives them very broad discretion. There's only a few instances which they should not be able to use it, like in this case, loss of funding, ambiguity in the bid, change in the workplace. All of these examples are not disputed. If you go, however, to the cases which look at whether you can just try to do something to get a better price, there's the Northrop Grumman price, more recent case, which said that involved the building of the space station, that the action there was not to save money, and therefore it was proper. And if I may briefly point your honors to the state cases. There are 3 state cases and then a 4th who specifically have dealt with this, and they have said, under state law, we're going to require the government to have some reason, some change in circumstances, something which would explain what their action is. And there is the Rytan case, which said otherwise they have an open license to dishonor contractual obligations. That's not what they specifically did here. I understand that there is pressure. We're talking about a wide argument they're making that this gives them completely unlimited discretion. So you had the Rytan case in Arizona. You have the Ram Engineering case in Kentucky, and you have the MB Fuel case in New Mexico, where actually the city of Albuquerque contracted for all its fuel requirements, and the supplier could not meet those requirements. So the court said, that's a good faith reason. So some predicate of some sort is required so that the exercise of that discretion is not without limitation.
All right, thank you.
Thank you.